Yes. This DJ will kick the floor in 3, 2, 1.
On the troll.
Hello and welcome back to Mzansi. We are back again, and I'm hoping that I'm not clapping, but I've adjusted. We are back again. It is that time of the night where we have to talk about the submission of Uzitulele Nxumalo for accused number 4, which is Maphisa. Yeah, so we are here to hear that. Other than that, what is an angle and where is this going?
Yeah.
That is our job. Our job is to give you that in terms of a public opinion, because that's where we fit in. Whatever that happens in court, we come here, we give you as it is, and we dissect where we can. We will try by all means to be as fast as we can in terms of giving you back the information, and then maybe we will spend more time in analyzing. You know what to do. Press the like button, press it like you mean it. We rely on you guys and watching the ads and subscribing. If you don't even want to watch the ads, but at least you can join membership also. I mean, not to say that there are no ads, but I'm just saying the other way you can assist the channel, just to say you are assisting the channel. Otherwise, the other way is definitely going through all these ads and not skipping them. That is really supporting the channel in that way. And we have our moderators that we appreciate too much. The first one that I've seen just by looking at the list right now is Tulitus. And we are saying hello to Tulitus and hi to you, moderator of this channel. We appreciate you guys and the members. Emily, let me not waste any time. Let me let you do what you do best and greet our people though.
Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us here again for another live stream. It's been long since we get to evaluate and analyze and dissect the Senzo Meyiwa trial. It's been a while. So I've had to outgrow covering other topics and coming back home. So it's been a while since I listened to a whole 4 hours. It's been a while. That's all I'm going to say. And yes, Mr. Anonymous, can you please explain why we couldn't do or continue or deliver on our promise that we made on the last live stream?
Oh, really? On the spot like that?
I feel like you can come up with a better explanation.
Okay. On the side of my side, I think I was not prepared enough.
Okay.
So I didn't want to come here unprepared. You know, guys, we respect you. We don't want to give you half-baked stuff. So I was not prepared.
Okay. That's what Mr. Anonymous says. He doesn't want to deliver half-baked goods. So we're going to have to cook some more and go back to the cooking pot. And hopefully when it's ready and it's in a condition that pleases him, it will be delivered. But until then, today, let's talk about what happened with the advocate Uzitulele Nxumalo, who was expected to bring an application to have the charges against accused number 4, Mthokoziseni Maphisa, dropped. Advocate Baloyi said that the matter was set down up to today for hearing of arguments by accused number 4, although he said that accused number 1 but recall that Nisi did not give a confirmation as to whether he will be applying or not, since legal aid said that they will only pay for the court appearance of 1 day and 2 hours of preparation time for 2 clients. Do you guys remember that? So counsel for discharge in terms of section 174, as well as the response of the state to that application. So the certain application was that of accused number 4 that was going to definitely be heard. Also recall that the other accused abandoned the move to have the charges dropped. That's the section 174 application. So Nxumalo started by describing Senzo as a well-known professional footballer who played for Orlando Pirates and was the goalkeeper in the Premier Soccer League and for the South African national team Bafana Bafana. He described that he was shot and killed in the house of his ex-girlfriend Miss Kelly Khumalo on the 26th of October 2014 while paying her a visit. And on the 16th of June 2020, the investigating team led by Brigadier Gininda, who is the head of the National Cold Case Unit, arrested accused number 2, Bongani Ntanzi, in respect of this case, and which ultimately led to being on the 19th of June 2020. Ntanzi made a confession before a commissioned officer, Kena Rapadu, and on the 24th, he made another confession before a magistrate, Ms. Grunier. And it was on the basis that led to the arrest of accused number 4. And on the 17th of July 2022, the trial commenced de novo, and it had been on the running road for a period of over 2 years, and it had been televised nationally and internationally and on print, and it has also been marked by billage during this period. Accused number 4 had been in attendance throughout this trial. It is no doubt that at some instances valuable court time had been wasted, according to him, right? And he said that the rationale for the rule in terms of section 174 was described in State versus Morewa. It caters for the prescript of the Constitution for fair criminal trial, namely the presumption of innocence on the pardon of the accused until proven guilty, and his or her right to silence. It further puts an upright end to a case which has no prospect of being successful in circumstances where the evidence falls short, even in proving a prima facie case against an accused, thus ensuring that the available court time is not wasted and unnecessary expenses not incurred. So Section 174 does not give the court to decide not to put the accused on his or her defense if there is a case to answer. There is no formula for or test applicable to all circumstances when deciding whether or not to discharge. Each case must be decided on its own merit in order to reach a just decision. He went on to a paragraph talking about the charges. He said that the accused, including accused number 4, are charged with the following charges, which is murder, attempted murder, and robbery with aggravating circumstances. He said that the charges are saying that the accused did unlawfully and intentionally kill Mr. Senzo Meyiwa, a 27-year-old man, by shooting him with a firearm. The murder was planned or premeditated. The death of the victim was caused by the accused attempting to commit or after having committed robbery with aggravating circumstances as defined in Section 1 of the Criminal Procedure Act 51 of 1977. The offense was committed by a group of persons or syndicate acting in execution or furtherance of a common purpose or conspiracy. Count number 2, attempted murder. The accused did unlawfully and intentionally attempted to kill Zandile Lorraine Khumalo, and other female person by shooting at her with a firearm. Other female person. And we are finding out today from Advocate Zitulele Nxumalo that this other female person, they were referring to Kelly Khumalo. Right? So that to me was kind of a shock.
So these guys, not only are they there they are also there for
attempting to kill
Zandi and Kelly Khumalo.
Yes.
Other family, other person. It's very interesting. Why don't they mention the name?
That is very strange. I was like, This is an interesting charge. It's an interesting charge.
Which answers the question that many people, in my opinion, that one person wrote here saying that this is a chance for the defense to call Kelly. You see, Kelly is other female person.
Other female person on count
Is
3.
other female person. You want to call other female person to come and testify? Do you think he's going to say otherwise when he's part of the people that were almost killed?
I'm actually shocked by this. I wasn't expecting it. I'm like, we moved on. The only charge of attempted murder I was aware of is that of Zandi Kumalo, because they said that the bullet grazed her foot, right? Or she was the fragments. It's not the bullet actually. It's the fragments of the bullet as it hit the tile. They hit her ankle.
Attempted to kill Zandi, ne?
Yes. That's the one that I was aware of. I did not know about this another female person.
What is the meaning of intentionally shooting, Senzo?
Intentionally, it means that they were moving towards it being a hit.
So there was a bit of change right there as we were busy thinking about it, that the theory seems to be changing.
Because if it wasn't intentional,
so we were going with the mastermind, intentional.
Yes, because without the intentional, it makes it a robbery gone wrong, right? So
which is not intentional.
So this came as a shock to me, you guys. I don't want to lie. So count 3.
This case is a very confused case.
It has layers, and the layers grow as it progresses, as the state continues to present its case.
It's a very confused case in a sense that
new stuff.
It's a confused case in a sense that it does not have a stand where it says this case is built on a robbery gone wrong or
a hit.
Because if you're saying it's a hit and Kelly is the mastermind, they also wanted to kill Kelly, the mastermind. You are charging them for that? For
other female person. Count 3, attempted murder, Zandi Kumalo, and other female person.
So,
and the way it's even being framed, other female person could mean more than one female.
Yes, persons.
Which also includes her mother, because there was a testimony of elbow before they took the phone, allegedly.
It is not well structured. The mother probably, if the user area 51, God bless you, thank you. The mother could have been assaulted, yes, maybe, according to the theory here, that they were fighting for a phone. But attempted murder? Was there shooting that went to Kelly Kumal?
Not on record.
So attempting to kill other female person, I thought Senzo was protecting me. Do you remember the theory?
Yes, that.
I think it comes from that theory.
Oh.
There could have been a theory maybe that was still not yet there, but people were trying to say maybe it was shoot from the back. There could have been a theory like that.
And that the target was Kelly. There was a theory like that. Even Sandy was speaking about it on interviews. That what if the target was
do you remember
sister?
saying at some point this case could have been, and it seemed as if it was going straight to Mandisa's door.
Yes.
But for some weird reason, for whatever odd, powerful, goddamn reasons, it turned. And the problem with this case turning and shifting the goalpost now and then, it did not change the case itself. In a sense that it is that's why I'm saying it's confused. It kept on changing these small points, but the whole body of the case never changed. So that's why this case has loopholes, in my opinion. It just doesn't make sense. It talks about a lot of things. If kube kuthiwa inkondlo ngesiZulu ngabe sithi ine lokhuzana ine mizwe eminingi, you know, it has many
rooms.
Yeah, it has many rooms in it. that are not supposed to be in the same body, same house. So it is a confused case, to say the least. For me, it is a very confused case. It's like someone was trying to create a theory somewhere, somehow something disturbs him, he changes the theory, but he forgets to change the other paragraphs, and then he points it somewhere else, and then he changes the theory, points to say that this is a case that had was conducted through the advocates such as Baloyi and the rest. It surprises me. How can a case that is of this magnitude, and you, if you read it as a not only one advocate, many advocate, if you guys were reading it, what did they think when they were going through it after it was finished? Which goes back to what we've been saying about Chauke. This case, in my opinion, it was not done when it was in Chauke's desk. It was not done. In fact, I would go as far as say it was 40% there. So you expected Chauke then to take that decision and say, yes, let's go to court with such. It was almost done when we were halfway in the very same year of 2005, I think. 2025, I think.
2025.
Yes. That's when it was finished. So it is well and good for people to blame Chauke. But I think we are at that state now that we are realizing with this case, it's not going in. There's no senage in this case. It is fighting.
There's too many contradictions. There's too many mushmash. There's too many, shifting the goalpost, like Mr. Anonymous was saying. It keeps shifting.
Yeah, it keeps shifting.
So I don't know. I don't know, Guti, where we're going to end up. But yeah, it is what it is. So count 3, the accused did unlawfully and intentionally assault Miss Kelly Khumalo and or Gladness Khumalo and did it with force and violence. Take a Samsung S4 cell phone, the property in lawful possession of Miss Kelly Khumalo or Gladness Khumalo. Count 4, possession of firearm. The accused did unlawful and intentionally had in their possession the firearm to with a 9mm CZ model 75 with obliterated serial number without being in possession of a license to possess the said firearm. So in respect of this count, the state alleges that the accused jointly possessed the firearm, which is the subject matter in this count. Count 5, possession.
So yes. Upon realizing that, well, you have nothing to charge these people as like one by one, you then say you are all holding that gun.
Yeah, all of them are holding the
so
firearm.
that you can hold also accused number 4.
So count 5, possession of ammunition. The accused did unlawfully and intentionally have their possession an unknown number of quantity of 9mm parabellum caliber ammunition without being in lawful possession of a firearm capable of firing such ammunition. So the summary of substantial facts: there were several other persons in the house, namely Miss Gladness Khumalo, the owner of the house, who is the mother of Kelly Khumalo, Miss Zandile Lorraine Khumalo, who is a sister to Kelly, and Mr. Longwetwala, boyfriend to Ms. Zandile Khumalo, Mr. Tumelo Madlala, friend to Mr. Senzo Meyiwa, and Mr. Mtokozisi Twala, friend of Senzo Meyiwa. In the lounge or dining room, a cell phone belonging to Ms. Kelly Khumalo was taken, and the assailant fled, dropping a hat on the premises. It is important to note that in respect of count 3 of the indictment, Ms. Kelly Khumalo was not called to testify despite her being the complainant in that count. Isn't that interesting?
It is very interesting, because you'll see that later on there is an attempt to create a person out of an affidavit because of that submission. There is a submission that Khumalo makes to say that there is only one person. We must tread carefully around taking a confession. I mean, taking evidence of one person and making it or using it to actually take this. Then later on, if you notice, there was an attempt to add an affidavit that it could have been very interesting, I think, for the judge if it was taken by our beloved Brigadier Gininda. Unfortunately, it is not so. It opens the hole, but we will expand on that when we reach there.
Now, the judge said that he thought there were two complainants. Baloyi confirmed it, and the other complainant is the mother. Ngumalo then said, in fact, both of them were not called before this court to come and testify about circumstances of the robbery which occurred in the house in their presence. The accused were acting in the state will allege that the accused were acting in common purpose. So Ngumalo turned to the duties of the prosecutor and argued that the prosecutor has a duty to pay attention to the contents of the docket. He cited the case of Minister of Police and another V. du Plessis. The summary of the substantive facts details that the deceased, Mr. Senzo Meyiwa, died during or after the commission of a robbery gone wrong. Brigadier Gininda, in his evidence, details a hit to kill the deceased and bases this argument in the investigations that were done. Ngumalo went into the cell phone evidence of Colonel Steyn, who testified on the analysis of cell phone records. Ngumalo argued this point after highlighting that Steyn allegedly found cell phone calls between Kelly and one of the accused. Now, he said, and I quote in his record, the record when he was testifying was saying that during his analysis, he discovered that Kelly Khumalo with number 2782704435 received a call from Ndulinkani with number 2773059203, and this appeared from the record of the 27th of July 2023. And according to Colonel Steyn, communication between the two numbers occurred in two separate occasions. That it was the 2nd of August 2024 and the 15th of October 2014, not 2024, my apologies, 2014. So the 2nd of August 2014 and the 15th of August 2014. The details of the communication are in Colonel Steyn's affidavit. As you can recall, guys, he did testify to this. So Ngumalo said that it is important to mention that the information from the central database of the South African Police Service was editable, and the state did not call a witness to authenticate it during the course of this trial. Now, you can recall, for those maybe who may not understand this part of evidence, which I felt like he should have added, to say that the document came in a PDF format that Ms. Pinkifa Ntilengem had said is not editable, right? And then it was translated to Excel. So it got moved from it being PDF to Excel, which was now editable. And he should have also emphasized that the format of the PDF that Pinkifa Ntilengem testified on had certain discrepancies compared to that of the Excel, right? Some of those discrepancies needed to also be highlighted in this part of evidence. So that's just my opinion. So the state, by this communication, intended to prove the communication between the mastermind, which according to Brigadier Gininda was Miss Kelly Khumalo and accused number 5. Accused number 5 then procured the services of his co-accused in the execution of the murder. So the evidence of Miss Pinkifa Ntilengem has stated that it revealed that Kelly Khumalo had received calls from Athama Fokat and the deceased, not accused number 5. So this is where we also evaluated this on the day that it happened. The number that Colonel Steyn had given to Fisoguhle Nkani, the defense came after the investigation, and they even put it to Steyn that number actually belongs to Athama Fokat. Do you remember that?
Mm-hmm. So
this is part of the reason why we are also saying that this evidence is.
And for one, it seems as if the charges and the reason not to charge the so-called what is it? The so-called mastermind.
Kelly Kumalo.
Allegedly Kelly Kumalo.
Allegedly.
It seems as if there was no let me say there was no agent, or there was nothing actually that was there. But look at this. Then then come this expert who tries to link this person, that Gininda keeps on going back, even when he's told that. But accused number 6 is not here. Gininda says no. It was prosecutor led. It was a decision. But look at what is happening in the court. The judge is expected to take a decision on the basis of that.
Yes.
I was expecting a judge who's seasoned as Rata to ask that question, is to say, since Kelly is not here, what am I to do with this? What am I to do with this evidence that comes in that seems to be linking Kelly, who's not here? By the way, what am I to do with this evidence? But we didn't see those questions. In fact, it was entertained and validated.
Yeah.
What is it doing in that court? That's a question for me. What is it going to do? After creating that link, where is it going to help the court?
Where?
Because let's say, for example, then you start a new trial for Kelly. Afterward, then Kelly wins the case. And then what about the fact that you have already taken these people down on the basis of mastermind, using those links and whatnot?
He says that there were discrepancies from the analysis. Ms. Vaintelengam could not give reasons for the discrepancies. Yes, this is where it caters for the whole moving of the document from a PDF file that was sent from Vodacom, set in the system of the SAPS, and then when now Kennel Steyn is working on it, he worked on it in Excel format. So the data of the cell phone records do not disclose such communication between Kelly Kumalo and accused number 5 before this court, which is something that was kind of, concluded to. But then somehow there was internet call data usage now. WhatsApp, there's no WhatsApp call in 2013. And now they looked at the estimate of data usage to say that because so much data was used, there was certainly an internet call between...
It sounded like one fella who was a forensic investigator, independent forensic investigator. It sounded like those type of evidence.
Yes.
I'm not going to be calling names, but it sounded like one fella who just create a campaign and then next thing it goes, everything flies.
Yeah, it moved to that. It moved to that after it was revealed that this number actually belongs to Arthur Mufukati. So now we move to it being an internet call. That's how everything happened and unfolded in that court. In fact, Kennel Steyn had to come twice to testify. Came the first time, then he came again. And when he came back, he came with the theory of the internet call. So the SMSs between Miss Kelly Kumalo and her sister, Zandile Kumalo, revealed the following. The trial commenced through the witnesses' evidence, and the witness evidence who were inside the house when the incident occurred, painting a picture of a robbery gone wrong. But when the trial progressed, it built around the assassination of the deceased. Brigadier Gininda described Kelly Kumalo as the mastermind and the trigger point in the execution of the deceased's murder. To that extent, he applied for a warrant of arrest against Miss Kelly Khumalo, which was never executed, as he says it was a prosecutorially led investigation. He said that he's well aware he said, and I quote, "I'm well aware, my lord, that the state did not bound or is not bound by the summary of substantial facts, which means that the evidence not disclosed or which differs from it would not be inadmissible on that ground alone." State versus Van Vuren, the court will nevertheless, in evaluation of the state's case, compare the evidence given with what the state indicated its case will be. State versus Khuluko, it is therefore crucial for the state's case to indicate that the accused entered into an alleged conspiracy agreement with Ms. Kelly Khumalo. Following such proof, accused number 4 cannot be convinced on any of the 3 counts against him.
Cannot be convicted.
Cannot be convicted, my apologies. Cannot be convicted on any of the 3 counts against him, and not the 4th or the 5th count. The legal position, he said that he ought to be acquitted if it's reasonably possible truth that he might be innocent. At the close of the state's case, when there is a discharge or a discharge is considered, the first question is therefore or evidence on which a reasonable person might convict. If not, the reasonable possibility that the defense evidence might supplement the state's case evidence. If the answer to either question is yes, there should be no discharge and the accused should be placed on the defense. This criticism permits the accused person to be placed on his defense even when there is no case to answer, merely in the exploitation that defense's evidence might supplement the prosecution case. To place the accused on his defense on those circumstances has usually been set out to be in conflict with the resumption of innocence. He quoted State versus Lubata. Clearly, a person ought not to be prosecuted in the absence of a minimum evidence upon which he might be convicted, in the expectation that at some state he might incriminate himself. So this reminded me of some investigators, I'm not going to mention them by name, who don't actually look for evidence before making arrests. They just are on the thrill and chase of making arrests. They make arrests and then the next day people walk.
To clarify this, then what Nqumalo is arguing is that the state seems to be relying on the fact that should the defense continue with the case in defense, then they might implicate accused number 4. Therefore, yes, then solidify their case that is weak or it has no merits when it comes to accused number 4.
Yes.
Which is a conflict of what they say you should be standing there for. It's really a complete different perspective where you say at some point you might implicate yourself one way or another.
If you're put on the witness box, you will implicate yourself, hoping. Or you may, in the middle of trial, feel like making a confession. So that is recognized by the common law principle that there should be a reasonable and probable cause to believe that the accused is guilty of an offense before prosecution is initiated. The Constitution or the constitutional protection afforded to dignity and the personal freedom seems to reinforce it. It ought to follow that if prosecution is not to be commenced without that minimum evidence, so should it be when evidence finally falls below the threshold. Preeminent to be where prosecution has exhausted the evidence and a conviction is no longer possible except by self-incrimination. A fair trial, in my view, will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights. So it has been held felt that credibility of state witnesses at this stage play a very limited role. In State versus Mpete and others, William Sinch held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. No reasonable person could possibly, emphasis on reasonable person.
And of course, that then takes into consideration that there are others who are not reasonable, which we do not know which person they are referring to, but it seems as if they could foresee that there are people who are not reasonable enough to actually do the right thing.
To summarize the position regarding the application, an accused person is entitled to be discharged at the close of the case of the prosecution if there's no possibility of a conviction, either than if he enters the witness box and incriminates himself. The credibility of witness evidence is only an issue where it has been effect that the evidence is so unreliable that it can be said that no evidence has been adduced. Whether evidence of the state witness implicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. An acquittal must be in the interest of justice. Circumstantial evidence in the state's case may be a relevant factor in deciding whether the case against the accused is so strong that it calls for a reply in the witness stand. It's against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. So Nxumalo then said that Constable Zungu testified that he was a constable employed by SAPS. He knows all the accused and remembers accused 4 and 4 slaughters, but not from back home. He narrated how Zungu met the accused there via Gwabeni and stuff. The whole story of what happened, that he had called Gwabeni, went to Carlton Center, and then according to the version of the state, Zungu was a single witness. It should be approached with caution. It is not sufficient for a conviction. And then he quoted a case R versus Mukwena. The evidence of Zungu was not corroborated in all material aspects or respect.
That is true.
Skhumbuzo Zungu was not called by the state to corroborate the version of Zungu insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Skhumbuzo Zungu at Carlton Center in Johannesburg.
So is Absalom Zungu.
Zungu is the only witness who met the accused at the Foslera's hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, accused number 5, to remove his vehicle because he had parked his vehicle that accused number 5 was traveling in. The other one he was traveling in, he went with them to go and buy liquor using an Uno motor vehicle. So he was traveling with accused 2 and 3 and the driver. This was the only time he had traveled with accused 2 and 3. Okay? Zungu does not place accused 4 traveling together. Nxumalo said Zungu doesn't mention accused 4 following the other accused to Gwabeni's room.
Even if he does, for argument's sake, the point of contention is that there is no one who has put accused number 4 inside or outside the house.
True, the scene of the incident.
They could have traveled, for all I care, if they were ever there with this Zungu fella. They could have traveled, but even this Zungu fella cannot actually with certainty put these people inside the house. It is with the speculations
yes
that they could have. So we cannot charge people on the basis of speculations.
Yes. And now the credibility of Zungu's testimony, as we can all see what happened with
It
his
is found
father.
wondering because when he is narrating about these accused
Yes.
as people that he knows, and then later he's found wondering, he's even saying that if it was accused number 1, if it was accused number 3, 4, 5, he would understand. You know, when he's is debunking and dance, which was somehow shooting yourself on the foot because you have initially said that you know these people.
Most certainly. So there is material contradictions between Zungu's statement and his evidence in chief. The contradictions affect his credibility. His credibility.
It is found wondering. Not only that, when I'm catching, but unfortunately, you still need to call Absalom for the state, which the state should have done because they were using Absalom that
Zungu's
much.
statement.
Yes, the state should have actually called Absalom Zungu.
They had Brigadier Gininda testify regarding his statement and the contents of it.
It is very funny how the
as if he's
state,
deceased.
in my opinion, has shielded the people that they should have called in that house when it comes to this evidence. Like, for example, Kwabin himself, we're not talking about an ancestor here. We're talking about someone who's here. But it is, to such an extent, even more surprising that we have seen the state fighting for affidavit of people who have passed away. It seems as if the state is very happy to actually push in the affidavits of people who are normal, more than just bringing the people who are still available and alive and to come and testify.
So during cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. But before then, he said that it's clear that Zungu didn't know accused number 4. He didn't know him. So now, speaking on that typed statement that was supposed to be accompanied with notes that he had written himself, he said that there are contradictions. He actually meant that accused 4 and 5 entered Gwabini's room and not accused 3. Remember the version of his testimony when he first testified, how it was contrary with what was written on the typed statement. Do you guys recall those smallanyana errors and mistakes that
the
were
names,
there?
confusion.
Which permitted for the defense to call upon the notes, because upon finding an explanation as to why there were so many discrepancies, he ended up saying that actually I had written notes somewhere, and somebody in Brigadier Gininda's office, a female, was typing the statement as he was narrating with his notes that he had written.
Guys, let's not forget to press the like button, please. For those who have not pressed it, for those who have pressed it, I'm sorry to be paying in there, but please press the like button, guys.
So during cross-examination by Mr. Ramasepele about Zungu mentioning, or what he had mentioned in his written statement, that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. He said, I think maybe it is the manner in which it is put here, but I did go to Tops with the gentleman. And please recall that in 2014, Top Spa did not open up until late afternoon on a Sunday.
Look, it's something of whether it's here or not there. It's just casting aspersion also from your side, because someone can come and say, I think I've seen someone saying that it was open and all that. There are different theories to that.
Okay,
so that theory put it with caution, in a sense that it is not factually proven.
Okay. So he said, we came back and there is a lady that just wanted to go nearby who had requested him to buy her a drink. And he did go out with that lady in his evidence.
Which was not the initial story also. the initial story was that we went out using an Uno, which later changed.
Yes.
And it added whatever that it added as then hence you'd see now we're talking about the lady.
So he said he was informed that he was going to conduct his own investigations with Brigadier Gininda, and that after that he would come back and inform him that he did tell General Leshabane that he was at the hostel. Now this is where he was narrating that part about him having gone and given his testimony to first, was it Brigadier Leshabane, and then Brigadier Gininda, but I think they meant General Leshabane, and then Brigadier Gininda then came into the picture. The reason was because he did not want to give General Leshabane this information that it was coming from him, that he did not have a certainty with regard to that. Clearly, Zungu had an axe to grind with the accused. Zungu testified further that on the 13th of November 2018, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier Gininda that he knew nothing and that there was nothing that he can talk about. So Brigadier Gininda told him that he was going to do his own investigation. At that meeting, Brigadier Gininda was with Brigadier Tony, and Zungu testified that relatives had to shoot him. He spoke of accused one over the phone and asked accused one why his relative wanted to shoot him, because he didn't know anything about this matter, and he did not know anything. It is clear from the response or the evidence of Zungu. He mentioned that he even on one occasion that he did not know anything about this case. So Zungu could not explain what was the occasion. The judge asked, are you saying that Zungu's evidence is not corroborated by any of the evidence led in this court? And Ngumalo said confidently, yes.
So yeah, this is the time now the judge was intending to use the affidavit of Makeleni as a supporting or collaborating.
Yeah, actually, this part he talked about Buthelezi, Jack Buthelezi.
And then he included Makeleni also in this part. That's how Makeleni came about, which later it will be a very fruitless exercise in a sense that the evidence of Makeleni was actually, I think it belongs to the Stenkham, or I mean, they are the people that took it are actually those people who were working on this case before Gininda started taking over.
It was in 2014.
So that's a problem that they are facing, which they cannot solve. I saw a lack of appetite to call such people, which is the reason why Baloyi seemed uneasy about that suggestion from the judge. It's not because those people, I doubt those people don't exist. They exist. But I think they are not in corroboration of any form. That's a problem. So therefore, to call, and one can actually say that if you were to call Stenkham, she, wherever she is, she probably is not happy about how her name has been, in this case, dragged. I doubt she'll come a happy person in this case. So you don't want to call someone like that.
They said that she decided to just write whatever was in her mind. Tumelo saying, no, she put words in my mouth about the gun with the wheel. I did not say that.
Exactly.
He even had a statement done in 2018 to say that I didn't say that. That woman is crazy. She just wrote everything from her head. That's the perception of Warrant Officer Steenkamp, according to the state.
And who would actually like to bring Steenkamp if you have watched Netflix documentary? I mean, she described these people who were in the house as people who were disinterested, people who were not showing that they just lost a friend and they were willing to help. So she's not a good person to bring if you want to solidify your case as a state. That's why then, to me, it seems as if there has been this cutting attack to people who do not share the same vision as what the state have. Be it through the witness, in fact, mostly through the witnesses, such as you were explaining about, was this guy, is it Mtogo or not Mtogo, the other one, Tumel. Yes. So there has been these attacks. Joyce Buthelezi, one can argue that she was also attacked one way or another. Makubo has been attacked through Zungu and others. There is that feeling. If you are not going to speak nice about us, we are going to attack you and discredit you before you even come here. There has been that feeling in my head. I could be wrong, but I mean, Steenkamp is not exempted from that also.
Yes. On the documentary, she did say that, you know what, as I was interviewing, in particular Kelly, she was slouched, reserved. She didn't want to say anything. She was cold, according to her version. And she said, I even asked for the child, that did they see anything? And she said, no, I will not allow you to interview my child. So yeah, it's pretty much it too. According to Warrant Officer Steenkamp, they were not willing to assist. That's what she read from her experience and from the past of working with other victims of a crime. She did not get the same energy that she usually gets from people who've been victims of a crime. So now the judge asked if whether what Nxumalo was saying, that Zungu's evidence is not corroborated by any evidence that was led in this court, and the confidence that Advocate Nxumalo there portrayed to say yes, and the judge said never, and Nxumalo said never, akajiki futhi akatatazeli, never. Well, the judge asked for the time and said they gave him the time. It was just before the short adjournment, but he said that there was a gentleman by the name of Buthelezi who went to see accused number 1. I think he meant actually accused number 2.
Let me ask you before you continue. Where does that help?
Actually, we're looking for something.
When it comes to corroborating the incident that happened there in that house, let us try to make sense with this. I was very confused with that submission from the judge. We are talking about something that happened in 2014, and
yes,
the people we are talking about is the people that claim to have seen these accused running out of the house. Okay, so how does that then compares with what happened during taking of the so-called confession later in 2020? How does that help in terms of collaborating or supporting whatever that happened during that day? Because Nxumalo's attack is on the basis of there is no collaboration as to what happened in that house.
Yes.
Not only Zungu did not see these people getting inside the house, but also with Zungu's theory of what happened during that day, it does not have someone who says, yes, for example, my uncle, or if it is my uncle, came and took me from Joburg. It does not have someone who says, yes, for example, I was in the house with my uncle as my name is Kwabin. yes, these things happen. Not anyone who was in the car when they went to buy whatever those diluted waters they wanted to buy. No one is coming from that car and saying, yes, by the way, we did go to buy alcohol, so therefore I saw what happened with the accused as they were moving. Like basically, that's what Nxumalo is
Zungu is the only one
is attacking.
Yes, it's the only one who came to testify.
How does then that move from 2014 to 2020?
Maybe he wanted to know if Buthelezi was also there that day, that Zungu was also there. Maybe. I'm just guessing. Maybe that was the aim. Maybe that was the direction to say, to poke, to try and find out whether Buthelezi was there or not.
It just doesn't make sense to me.
And also, to remind or to create that angle that Ntanzi may have made admissions to Buthelezi that correlate with his so-called confession. But I have a different view of that. But actually, I did ask Uguti, what is the point of asking about Buthelezi? Because I was trying to find a reason as to why he would now want to infuse Buthelezi in Nxumalo's.
He is debunking the issue of Zungu's theory not being supported by anyone of these people that he has mentioned.
Yes.
He's trying to, but unfortunately, with his wisdom, smartness, whatever that you might call it, in trying to poke the holes, it has no merit.
Well, he said that Buthelezi went to see accused number 2 to give him some washing items. He meant toiletries in Rustenburg, next to some supermarket. It was actually next to a bank, I think Absa Bank, according to the testimony, if I recall it correctly. There and then there's another piece of evidence of accused number 1 drinking some Irish whiskey and exclaimed, Senzo is no more, Senzo is no more. And I'm like,
listen to that.
What is going on?
He's still trying to debunk the fact that Zungu is the only witness
who saw all of that.
That saw all of that. That could have other ulterior motives to actually take these people down. Nxumalo has demonstrated the through poking holes and contradictions that happened through this testimony to say this person could could just be a weapon to actually take these people down, nothing else, through those loopholes that are clear and obvious that this man is not credible. So the theory of the whiskey, we are still then going back to reference the very same only person that that is being contested. You are still going back to reference that person and say, oh, the whiskey comes from who? From the very same man.
Zungu.
Yes.
Constable Sizwe Zungu. Nxumalo said that there was absolutely nothing in the evidence of Zungu that implicated the accused in the commission of the offense. In fact, Zungu testified about, he referred to not less than 5 people that he met on that day, and such people were not called as witnesses. On the 7th of September 2023, the court referred to hearsay evidence of Zungu. He also addressed the meeting the court referred to between Ntanzi and Jack Buthelezi. Buthelezi said that upon the meeting that transpired, he said that Bongani said that there was a party and they said he was in the company of his friends. And he said that he was with Maphisa and them when he referred to his friends. By Maphisa, it was never pursued through the evidence in chief to this particular witness, which was Jack Buthelezi, by the state to clarify to the witness which Maphisa was he referring to when he said that he was with Maphisa at a certain party with friends at Vosloorus. Now, what I remember from Jack Buthelez's evidence or testimony is that when he went inside that car and the police stood outside and he was left with Ntanzi inside that car, he was handcuffed, and he did say that he did not smell pleasant, and Ntanzi did say that he had not bathed for days because since they arrested him, there were no toiletries, nothing.
And we cannot forget that the very same day that happened, that Buthelezi now that is being used, the same judge claimed that this Buthelezi was threatened to actually tell this type of story.
And his version, which is now, to my surprise, getting twisted, is that he said, as he entered the car, Ntanzi told him that the police are saying that I was with Maphisa and them. That's what Ntanzi said to Buthelezi, that the police are accusing me of having done this crime, of having been there at the hostel. They are saying that I was with Maphisa and them.
Yes.
So now it has been twisted to say, okay, maybe Ntanzi made some kind of admissions to Jack Buthelezi to say I was with Maphisa, which coincides with the confession. Court is the battlefield of narratives. Yo!
More so if you are dealing with a very old fella who believes in his own voice, it becomes even more difficult.
Problem. It is like, how did this move from the witness saying this to the witness saying something totally different? So Nxumalo moved now to the common purpose doctrine. He argued that Zungu's evidence does not detail a plan by the accused to assassinate Meyiwa. Nxumalo argued in the absence of a prior agreement to kill Meyiwa that it is important to apply the principles stated in the case of S versus Mgedezi, which include the presence at the scene. There's no evidence that accused number 4 was at the scene, either circumstantial or direct. The judge asked about the confessions, and Nxumalo said he was still coming to the confessions. In fact, there was a bit of a giggling moment there between
Can
Nxumalo
he even use confession? I mean, common sense. Confession cannot be used against other accused. It is only weighing on the people who confessed.
I get today he was trying to spin this law Mtakabao in action, in full display. Today I saw it trying to be twisted, and that law of saying that you cannot implicate the other accused in a confession, it's in the Constitution, that one. So now he quoted another section somewhere else. And he was trying to say that the state is allowed to go after a person based on what they read in the confession. In fact, let me go through it now. So after that moment of the defense now giggling among each other, the judge changed his face. He started asking them, why are you laughing? And Nxumalo was like, okay, we're just surprised by the mentioning of confessions, that's all. And the judge said that he'll tell them what he's thinking, not what they think he's thinking. Okay, so he took offense to that. He wanted Nxumalo to read him section 218 and 217. Balo is the one who now took a book and started reading, and he was reading the part where it was talking about a confession being taken or being proven to be taken freely and voluntarily. The judge then said, that's not the section that I want. Give me that book so that I read it. And then what he found was the passage, that passage that he read himself. It spoke of the admissibility of facts discovered by means of an inadmissible confession. So in his explanation, he said that evidence may be admitted by confession, Gininda read the confession. In fact, he narrated the whole process of the confession being taken by Colonel Rapadu and then being read by Gininda from Colonel Rapadu, and then the one that was taken by Magistrate Cronier being given to Brigadier Ginindi, and then Brigadier Ginindi reading the confession and acquired the knowledge by reading that evidence. And by that, it is admissible to him. But it is not admissible for the co-accused. So by the mere fact of Brigadier Gininda reading the confession, if the confession in the confession accused number 4 is implicated, then he has every right to go after accused number 4. Even though the Constitution is saying
it can be used, it cannot be used alone. I think that's the point that is important. It cannot be used alone, even if it's there. There should be other supporting evidence for you to actually consider going after accused number 4. So let us clarify some of the myth that I see here, and because I don't want you guys to go out here and make these people next thing they call us stupid. We have names that we get these days. Now, I want to clarify the issue of common purpose.
Yeah.
On the basis, first of all, I would like to submit that for whatever odd reasons, the choice of a person who decided to go for Section 174 is excellent. In a sense that this person does not have any other evidence. As I said, Latif Nis's submission, if it was made, it would have been just to feel. It was basically a feel. There was no hope for it, in my own opinion, that it would have succeeded. But with accused number 4, in fact, if we were in a different court, one can argue that he's the right person, because you yourself have been asking why is accused number 4 there? And you even said that Ngumalo was on a holiday.
We waited and waited.
So, to submit Ngumalo debunking even the DNA and everything else that was submitted, crazily enough that they had to submit a DNA based on the fact that there were few common regions, which is not how the DNA works.
Yeah.
That is basically how desperate they were to actually include accused number 4. That's why Ngumalo was more confident to say that I will continue regardless of the pay. I will continue, because this is going to show the judge how biased the judge is. Before even Baloyi submit, I think accused number 4 has grounds actually to be acquitted highly if this court was never biased, which we will see. We will test the waters with this. I'm happy that this is the person who did it alone, because you know what was going to happen, Amen?
What?
If they all did it, it was going to be easy to just dismiss all of them. Because others have, they would then give the points like such as guns and 1, 2, 3, other stuff. It was going to be easy to dismiss all of them.
True.
But this person alone is a person that has been questioned a lot as to why that person is there. Hence, then the issue of DNA and whatnot, which did not stick. So this person ought to be acquitted one way or another. But unfortunately, it's not going to happen probably in that court. But that is how then you'll see how much of how biased the judge is, because even the question that is asking in debunking, that you guys are saying there's debunking, they are not solid, as we have proven in some of them. They are just going left. They are not even in line with what is being submitted there as points that are submitted by Ngumalo to debunk this whole thing. So he's failing already.
And we are forced to shame.
Okay, now let us go to common purpose issue. So common purpose is not an issue of therefore. And I want to correct that. It's not an issue of therefore. So if you are charged on common purpose, it does not necessarily mean that if one person is acquitted, therefore everyone is going to be acquitted. And I repeat that because I want you guys to go out, when you go out and argue, you argue properly. It does not mean that.
Okay.
But one person can be acquitted, even though you guys were charged on common purpose. Do you understand?
Yeah.
But it does not collapse the state's case.
Thing.
Yes, it might have an impact on the remaining accused in terms of weakening the case. But it does not necessarily mean that everyone then is going to be acquitted.
Okay.
So what happens when one person is acquitted? Then you guys are judged individually on evidence. That is what is going to happen if they were to acquit accused number 4.
Okay.
So it doesn't mean automatically that everyone, I have to agree with the, what we call it, the legal aid in refusing everyone else. But I do not agree with them refusing even Ngumang. That was wrong. They use a blanket approach because everyone, as I'm saying that, the issue of them all going in and it could have allowed the very same outcome as they got with the case. To say, yes, everyone, you guys have something to say. So do not be confused when you are arguing, wherever you are arguing. Section 174, if it is applied and it's successful, would accuse number 4, it will acquit accuse number 4. It will not necessarily collapse the state's case. They will still continue. Those who are left, they will still have something to answer for.
Okay. Fair enough. Well, Ngumalo moved on after the judge read the legal provision on confessions. He highlighted that the second point, which is awareness of the attack, and says that there's no evidence that suggests that Maphisa was aware that the murder was taking place. Kelly was not called for the third count on the indictment. Ngumalo moved now to the evidence of the identity and argued that then this needs to be direct or circumstantial, and in this case there were no witnesses that placed Maphisa at the scene. The bulk of evidence of Zungu refers to hearsay evidence. He referred to people who were never called to court to corroborate his evidence. Witnesses that testified in court also did not place him at the scene. The assertion that accused number 4 entered the house must be rejected as false without reasonable doubt. They did not find support from the witnesses. Mtogozi Sitwala, who ran out of the house after shots were fired, did not mention this, nor was it raised by the state or when the state was leading the witness, nor the witnesses, Mrs. Makete, who's in Tabiseng Makete, do you guys still remember her? And Mr. Ngache, the son of Ubaba Ngache, which were the neighbors of Gladness Kumalo, observed another intruder after he had fled the scene. Now, reading the confession, it is clear that he did not do any investigations in order to corroborate and find any evidence to the commission of the offense. I felt so good hearing this. I was like, oh my God, I've been saying this for years. The investigation. Where's the investigation? So he said that I'm saying this because it is true that accused number 4 entered the house after the 2 intruders had left. This was supposed to be investigated and not investigation emanated from this point. He moved now to the DNA and said that Maphisa was excluded from all samples done by Captain Masitla. In the report, it read, and I quote, Mtogozi Seni Maphisa was excluded from all the samples. It is in the report, guys. In the report.
Well, not in Ginindi's head.
Or the judge.
Yes.
Because he's the one who came up with this inconclusive thing. he read the record where Masetla explained the difference between the chromosomes and how they matched. And he said that we matched them all together. All of them. 99.9. Yeah, so Brigadier Gininda said that because accused 4's DNA read in one of the regions, this means that it's a positive. The DNA that was found at the hat. Remember how now we got introduced to another piece of evidence that was totally brand new under the cross-examination of Brigadier Gininda. He said that accused number 4 came back after accused number 1 and 2 fled the scene, and he touched the hat. And then he left. So he went inside the house to touch the hat, and then he left, and he left the hat. God, we've been through a lot. After this trial, I need therapy because there's no way. There's no way. I have been listening to all this nonsense and trying to make sense of it. I'm like, what is going on? But it got introduced just before he was done with his cross-examination, and I was blown away. I still am.
It was in a form of suggestion to say that it could have happened that he went inside and
I still am.
For whatever reason, then there was a drop of sweat or something.
And he's doing all of this despite the report saying that it wasn't a match. I give up. So that does not find expression in Masetla's evidence, according to Ngumalo. And I heard the judges there saying, what can be said?
One case of apartheid might assist in terms of defending this situation. I don't think then the cases that I knew coming from 2020 something or 2018 going down 2010 are going to assist. I think to reference those cases will be shooting yourself on if you must deal with those ones of apartheid times, then you'll be able to defend the situation.
Ngumalo moved now to the evidence of Sergeant Vusmusi Mohani transporting accused 2 to make those 2 confessions. Then he went to arrest accused number 4. Gininda said that he arrested accused number 4 based on their confession. Ngumalo said Brigadier Gininda had no evidence against accused number 4 before the confessions were obtained. Confessions is not admissible against another in terms of Section 219 of the Criminal Procedure Act. No confession made by any person shall be admissible as evidence against another person. There are no bank records that show that accused number 4 received proceeds from the mastermind, which show the inflow and outflow of funds, which are immaterial in the present case. Aware kovela my bank statements to show that money moved. Yabo. This was a hit.
I'm confused. You're saying they are immaterial.
He's saying that they are immaterial in the present case. The flowing of funds via bank statement. We're not talking about a picture.
They are material or they are immaterial?
Immaterial.
Okay.
So after the long adjournment, he said that joint possession of a firearm, particularly an illegal one, requires proof that more than one person intended to possess the firearm and that they did so together, not that one person possesses it on behalf of a group. The mere presence of a group during a robbery where a firearm is used does not automatically equate to possession. Evidence.
Emily, I'm not an English person, but I don't think immaterial.
What do you mean now?
When you are submitting that, you cannot say that the banks and the proceeds, the flow of cash is immaterial.
It is immaterial in this case because it's not there. It's not there. Is it there?
So it's immaterial because it's not there.
It's not. The state has not presented such evidence.
I think you would have said if you were submitting that it's material, but it's not there. If you want to prove your case, it is material.
But Ngumalo said it's immaterial, and I agree with him because it's not there.
I don't know. I'm not an English person, but I think when you say it's immaterial, you're saying it's irrelevant.
How can it be relevant when it's not there? It doesn't exist.
But you are saying your submission is that the flow of cash.
It's not my submission. It's
Okay, Ngumalo's submission is that the flow of cash would have assisted in maybe pinning accused.
Yes.
It's immaterial.
It's immaterial to this case because of the state. They didn't present it. How can it be material if it's not presented? Mr. Anonymous, you're confusing me.
Okay, let's continue. Somebody's saying Mr. Anonymous, their immaterial was in relation to transaction on Maphisa's bank. Said yes, I'm saying that. I'm not against that. I'm saying if you submit that they are not there, they are not presented. So a proof is not presented. That is very material to actually prove that actually
you are saying
there was
the same thing, but you are saying it in your way. But you are literally saying the same thing that Ngumalo is saying.
Okay. I could be wrong.
You are saying the same thing, but you want to use your English.
No, it's not.
And Ngumalo used his English, but you mean the same thing. It's immaterial. There's no inflow, outflow. There are no bank statements to show that money went into this account. It was so much. It was a hit. So it's non-existence of such inflow, outflow of cash flows is immaterial to the state because it's not there. Aiko.
Oh, so you said it's immaterial to the state.
It did say but I thought you would catch it. You're not catching it.
I'm not, but it's okay. Thank you, Alf Mash. Thank you. God bless you. God bless you. I'm just.
Yeah, you say it in your way, and he said it in this, but it means the same thing to me as I'm listening to what you're saying and what he said. It means the same thing.
So immaterial in a sense that there's no evidence.
There's nothing.
So it becomes immaterial
in this case. That evidence is important, but it's not there. Is it not important? I guess they're saying it's a hit.
I think me and Sbongile are speaking one language, but it's fine. Okay. It's our understanding, Sbongile, I mean, that it would have been material if they were there, but they are not there. So it renders them, basically there's no link. But to say, therefore, then if they are not there, they are immaterial.
But it means the same thing to me. I don't know. I could be wrong, but I don't find difficulty in what you say.
Now there is no material evidence as such, therefore immaterial.
Exactly.
Okay. No, yes. I get you.
Yes. Exactly. Spongile. Who is it? Thank you. No,
it's not Spongile. Spongile would be
who is it? Who said it? It's VMAG.
Yeah.
Thank you, VMAG. Thank you. You simplified it. Thank you. Let's move on now. The mere presence of a group during a robbery with a firearm is used does not automatically equate to possession. Evidence must show a common purpose to possess a firearm, with the actual possessor holding it on behalf of the group or the group intending for one of them to possess it on their behalf.
Mm-hmm.
And on the cross-examination of Tumelo Madlala, Bayram Sipili was asked if the firearm had a wheel, something that looked like a wheel or a rotating object on the side. Madlala said he looked at it. Like he already said, he did not take a lot of time to observe that particular firearm, and to him it appeared as though it was a firearm that had a wheel on it. And then, of course, the state came back in re-examination and it...
They're not experts, these people.
They don't know about firearms. They have no firearm knowledge, so they can't testify about firearms.
Through Gininda, through you say. Please press the like button, guys. 547, we appreciate you guys for being here. Please subscribe and press the like button. Thank you.
Nisi now asked also on record, he was quoting the record that was the cross-examination of Advocate Nisi. He asked for a distinctive feature that looked like it had a wheel. And Mr. Madlala responded and said, yes, I've already said that. And when I looked at it, I saw it, the front portion of it.
You know what is funny? What is funny is that this man, they come here and Bonya Ustenkam Guri was wrong, and then they go back and say the same thing on a cross-examination.
Yes. and then re-examination, they change it again. That no, I saw it from the front. If you saw it from the front, it means it was pointed at you. Does that? It means it was pointed. Numalo said that there is no independent evidence that accused 4 was part of a conspiracy to kill the deceased or participate in a robbery, except what is contained in the confession statements of accused number 2. The state has failed to establish a prima facie case, and accused number 4 must be acquitted. Numalo said that, in short,
I agree.
What he's submitting in his heads of argument is that there's no evidence that has been tendered by the state upon which this honorable court may convict accused number 4. The onus is on the accused person to prove their innocence. It has always been the duty of the state to prove the case beyond reasonable doubt as far as 1961. It is not the duty of accused number 4 to go to the witness box and supplement the state's case in any way or incriminate themselves. By so doing, they are incriminating themselves, okay? He said, I submit that accused number 4 be acquitted and discharged in terms of the provision of Section 174 Act 51 of 1977, dated at Pretoria on the 16th. Is it the 16th or the 15th? I don't remember properly. I think 16. I heard the 16th of August 2025. Now that marked the end of Advocate Nxumalo's argument.
Marvelous job.
I also had some bit of a complaint, Mina, in drama. I love my performative advocates and attorneys.
Yeah.
I love the passion in argument. I live for my lord, there's no way this client of mine can stay. They must be acquitted. You understand? I love that.
It doesn't work with Rata, that thing. I get it, we have seen with Mshololo. The passion there does not work. Look at Mshololo.
I'm just saying, like, I miss the theatrics.
That thing of coming with that, yeah.
I love it when lawyers do that.
We are not in constitutional court here. What matters is what you submitted. We are not going to discuss with you there. We are debunking you there. We are not discussing the case. You didn't want to miss some of the things that are crucial. Considering that this case is long.
Yeah.
You can't just recall from the bar.
No, you can't.
I gotta recall their brains bar. You get from the bar.
The bar.
So it's unfortunate that
the bar.
You are not going to see such. I think, but you might see such. You would have seen such with Mngomezulu.
Even
because they are not fans. Mngomezulu, for example, is forced to carry everything with it. He was forced because he could not see some of the stuff when he was reading there. So he was forced. So I mean, Nxumalo is got fresh eyes. Why not then use those fresh eyes to actually deal with and actually avoid the eye contact with Rata? Because
he did avoid the eye contact.
He buys a lot of he bounces a lot of things to you. Next thing you get distracted. Laura, thank you very much. But buy Rata chill pill today. Emily, okay, we'll definitely buy a chill pill, but not for Rata. I think we'll buy for Emily. For Emil, yeah, we definitely buy a chill pill. But I think it helps sometimes. Mahurute, thank you very much for 4 members have been acquitted. 4 members must be acquitted. Fully agree. So 4 members.
4 members, yay!
Yes, thank you. On behalf of those members and the channel itself, thank you. We appreciate that. The lights are gonna be on. So I've got you done.
Yeah, I am done.
Thank you. You were very fast, I must say.
I have to be.
We can allow a 2 minutes call. And then
Please
I see
call in.
Vimac is saying Thank you. Vimex is saying nothing, just giving you a proper cold drink. We appreciate it, Vimac.
Thank you,
Thank you.
Vimac.
It's a difficult month, this one, as if you guys knew. Right.
Thank you.
The calls are, let me check the phones first, because next thing I'll be saying the calls are open.
Oh, and I know Mr. Anonymous doesn't like doing this, but you know what, guys? Mina ngiyayibongela. Thank you for 40,000 subscribers. Thank you.
Oh, yeah.
Ngiyantanda. Thank
Yeah, we've
you.
reached that 40,000 already.
It's a milestone, okay? I am grateful.
It's difficult. Hey.
Thank you, guys.
People don't like the truth, man.
Thank you.
Someone was trying to call, but we did not answer. I think you can call now.
And to even reach it on such a difficult...
But how are you, Emily? Emily, you're talking to... Okay, I won't be saying the name.
For safety.
Yeah,
Impulses.
I think you can call us. You can call us.
You can call.
But not today. Not now. Maybe after.
Or after the show. Is it something that's
Mzansi, hello.
exclusive?
Hi, Miss Ano and Sis Emily.
Hi, how are you?
I'm very well, thanks. Thanks for the good summary, a true reflection of the events of the day. I'll start at the end, and then I'll start at the end of the conversation and go to the beginning.
Okay.
Mr. Ano, the Makaleni story that the judge wants to bring Makaleni into this. He was confident that Giminda is the one who took the back. That's why I wanted to put that through the back door. But, mate, Makaleni is dead. And even his evidence should never have seen the light of that court. But it was forced to it. But where did it take us? It didn't take us anywhere. Accused number 4, Mr. Ano, we always say, what is he doing there?
Yes.
What did he do?
Yes.
Even up to today, we don't know what is the corroboration of saying readings are being read by DNA. It's a waste of our time. That is not corroboration. You need to place the guy inside the house by the witnesses.
Yes.
Not some sweat falling on the head. Come on. Yeah. And I know, Mr. Ano, I was not alone, including you and Sis Emily. We used to think Advocate Numalo is sleeping in that court, man. Yesterday, he showed us that the guy was not sleeping, man. The guy went for broke, man.
Yes.
The arguments were very, very, very good. I used to underrate him, but after listening to that one, a reasonable judge will just have to acquit Maphisa, because Maphisa must go back to Louis Cop and sleep and save his sentence that he said.
Thank you.
Yeah, that's what I think.
Thank you. We appreciate that part.
Thanks. Yeah. No, thanks, guys. Thanks for the good work. Let me give others a chance to go.
Thank you.
Thank you. He must go back to wake up and sleep. And rest. Waking up every day, going to court.
Yes, let's hear what other people... Hey, happy belated day, Nat. I was told about your birthday.
Yes, I told Mr. Anonymous that it's Nat's birthday.
Happy belated day. And Poe, I think I wrote it down.
So
Poe,
everybody wish Nat a happy birthday, even though it's belated, like with a couple of hours.
Yes,
but
yes.
wish her happy birthday, okay?
We appreciate you, this side. You have been there for this channel. In difficult times, we are here because people like you, they stand and say, not in my watch.
Not on my watch.
Sizwe, hi. I saw you came in late to mark the register. And then Mpo, get well, Mpo. I saw you said you are sick. You came here to press the like button. Get well. Yeah, that's basically it. This is the time where I go through... Someone say, I agree with Emil because Ngumalo thought he is good, but most of the time he was reading and no eye contact. Very good. Ngumalo is good, guys. Don't take the fact that he was reading. There is no... it does not help in some courts to actually have an eye contact with this judge. And in my own opinion, I would actually avoid it by all means. I mean, it doesn't help because it gives him ideas that you are weak in a sense, then they want to start having this conversation with you, in my opinion, to distract you.
Yeah, I've seen him play that game too many times.
Yeah, so I don't think I would have, I can blame him. I like what he did. I was just listening to what he was conveying. Very good. Very good. You can't fault it. You cannot fault it. This is where I mark the rages. I press the like button. Before I do that, then I start with Lula Masirai up there. Thank you. We appreciate you guys. Alpha Mesh, Siyabonga, thank you, and God bless you, Alf. May God increase you from where you took from. We appreciate you. Lindiwe, thank you, Lindiwe, for being here. John, Siyabonga, Siyabonga, John, even reminding people, please like the video. I'm trying to... something is happening. Ndazi, Leah, thank you very much. Lee Boshomane, thank you. Even thanking the use on behalf of the channel. Mpumizwane, thank you. Siyabonga. Chuku Anna, thank you. Juanita Africa Gibbs, thank you very much. We appreciate you. Let's see. Tlaki Mutlaudi, our member, thank you. Siyabonga. David Mabuza, Swanin Madod, young talento. I knew it was coming because it was refusing to do what I say it must do. But it's fine. Let's see, where was I? It becomes even more difficult, but I would read from this list because this list will not tell me lie. Okay, even this one is lying to me. Okay, Nat, thank you and happy belated day. Thank you, we appreciate you. This side, Metu Mhlanga, Siyabonga. Guys are correcting me on that immaterial thing, and I concede, guys. I forgot to say I concede.
Hey,
Nilo,
that's
LHM. Sorry, man. It's a lawyer on me. Lola, thank you, our member. Thank you. God bless you, Lord. We appreciate the tea. Lindiwe, I've mentioned you, Mayana Ndanganeni. Thank you very much. We appreciate you. Sizwe 18, our good member, our good Zanzi badge. We appreciate you, Sizwe. Let me see. Who am I missing here? God bless you, Lord. Increase. Cool, guys. We appreciate you. Hey, my daughter. Mahut. God bless you. Thank you. Should be nisikhumbule. Emmanuel Maganjera, all the way from Zim, at the team Anu and Emily. Thank you, we appreciate you, Emmanuel. I'm just ikangapa, itlb bafo those who watch soccer, they would know. Ngikengapa. Kunjalo nje. Laba bethe bazoshaya. Beshaya ibhakajuju. Bangobani wona? Shango plump. Yeah, asiqhubeke njalo nje bafethu sithi Chuku, I've mentioned you, and let me see. Bafethu bongiwe la K manje sengiyeqake manje sengibiza laba ngajwayele ukubabiza phela. Sibanda Skhathele, thank you very much. Siyabonga. Vimek, God bless you. Siyabonga kakhulu. Nkulunkulu akubusisa kwandizele sikhwameni mfethu. Kungapheli. Thobani Dube, siyabonga. Thobani siyakubona, siyabonga. God bless you. Ngihlala ngoholoko ke manje sibone ukuthi Thobani engazivamisile ukubabiza who are always here. Kodwa ke igama lakho phela manje ngishaya nganza kwethu. Kanti ngize ngilifunde. Bafethu no ubani lo uvulenzani Bulenzana or Vulenzana, I think it's Venda. Thank you very much. Siyabonga. Uthi naye thank you. Mfundise phela isivenda bafethu. Mfundise isivenda ngingasali ngaphandle ngirenda. Uhamba shivenda. Ngirenda. Ayawole ngithanda lapho ke mina. That's the most interesting part.
But the whole laying on the floor situation. But they do it with pride.
Angivusa manxeba madoda. Uncle Nace, thank you very much, our member. We appreciate you guys. Angivusa manxeba, guys. I'm just reminding you ukuthi phela nidliwe and oda nisazokhipha isibhongo kwiKaizer Chiefs phela. How nizoyishaya iKaizer Chiefs ngiyanazi nini. Ningobani? Anishawa kaningi nini? Anishawa kabili. Kulandelana? Ngeke. Masandawana. So besinani sisupporta njengomakhelwane siyasupportana ke thina asinankinga nje kodwa nje ngeke impela sivume ukuthi idube limthende nizenzele phela lose 12 points nje ningakaze lose hayibo ningayenzi lo nto madoda bafethu ziyabuya lapha kwa Superbad inangibiza abantu ngegama sorry Emil but ziyabuya lapha into eyenzakalayo ke uthola ukuthi uthi utshela ukuthi kuzokwenzeka okunye Seb Nzonzi thank you very much we appreciate you uthola ukuthi kuzokwenzeka okunye kuvele okunye kuvele ingane yomfana uthi gadi intombazana kuvele ingane yomfana Alfmesh please like guys buka nje kuthiwa Menani please like nakho nje buka nje Alfmesh uthi khumbulani press the like button guys why not singafika 400 kanti nikhona bafethu hawu seze hawu bafethu hawu kahleni bafethu hawu akubizi imali akuthatha imali akucosule next kuwe you just press the like button boy Tumelo MC Master it's been a while man it's been a while since I read this name maybe I've been jumping it I'm trying to find people who are just basically new or not new per se yeah my hope is to increase the membership to 4 months. Hey, my daughter. Sbong.
Thank you.
That's thank you very much. We appreciate that part. Mina May tumhlanga. Yeah, bengibheka wena phela ngapha anguboni. Siyabonga bafethu. Thank you very much. I think for now Emily it's better we sleep because next thing usibanda lapha uthola ukuthi uyena ozo.
I will cry.
Pedro,
please,
thank you.
Advocate Malo, you better not do that. He needs to be the one arguing this. Okay, I can't. Not after such a fruitful day. No.
Next thing will be, my lord, what I meant is that people must lie in their bed.
Tomorrow. We are wrapping this up tomorrow, okay?
My lord, what I meant, people must lie in their bed. The defense said that, not the state.
No, please.
You know, so it can happen.
No.
In a good day, whoever
he
is
needs to do it. He made his bed.
No. I mean, it's part of the states. Part of the states. Part of the states.
Guys, I can't take.
Can you imagine Sibana comes with 35 pages there that Maloi had written, and then
I'm not ready.
So that means 35 days you're gonna be sitting here for 35 days listening to that man arguing for one person to be acquitted. One person to be acquitted. Do you know how he was reading the numbers of cell phone? Which state? Cell phone 6067. So
was the most painful time, guys.
I want
don't
you
understand.
And then Sibana will be like, I want you to go back now and read that one up there. The 3 numbers on top.
That whole thing took 3 days.
Just to prove that there was a connection between Kelly and accused number 5.
I think it was Judge Rato eventually said, you know what, isn't there another way we can do this?
The cell phone 07.
Even he was tired.
Cell phone Wiseman Delani, thank you, Siabo. Press the like button, guys.
Advocate Baloyi needs to be the one who closes his case.
Go back to that number.
This is his moment.
I want you to go back to that number. My lord, the defense is the one that started this, you know, the theater that comes with that man. My lord, they started. Who started? So you'll be reading Shafon the whole day.
Shafon. Plus 27359.
Yeah, plus 27359.
And then Pinky Fine telling him. The number is 1, 2, 3, 5. I'm like, yo.
What if tomorrow is Mother's Day to shine?
Oh my God, this thing is too long. It's taking too long. It's taking too long.
I mean, either way, they are going to win. So they might as well put Spanda.
Don't say that.
I saw him smiling. I was like, this one is taking this one.
You saw him smiling. Please don't say that. For me, who has to deliver for my people, listening to Spanda is not easy.
We can go back, my lord, and listen to the record. The record can speak for itself, my lord.
I want to cry every time he's.
Can you imagine the whole doctor? The record can speak for itself, my lord.
It's torture. I hope not. I hope Advocate Baloyi is the one.
Now, if you guys press the like button up until 400, I'm telling you, definitely Baloyi is gonna be the one dealing with those heads of argument.
I cannot deal. No, I'm too happy. I don't want this happiness to go.
Oh, the cause. They are not here when Katerina, unfortunately. But it's okay. We still have a day tomorrow. Today, actually. Let's hear what Baloyi has. I'm sure Baloyi is going to make you guys talk. Save your time.
Yeah.
Save your time. And then, Nkosinati, Zagwe, thank you, our member. You're laughing. Yeah, press the like button. And if you don't, if we end here, 358, definitely Sibanda tomorrow. It's not a negotiation. Sibanda is going to be leading the evidence tomorrow. So press the like button. My lord, we can read the record. The record speaks for itself.
No, I'm not ready. I'm not ready for that.
My learned colleague now is fighting because it's my turn. It's my turn, my lord.
Oh my God. No,
What are you saying? You must go do research.
No, I think
You're saying you must go be a scholar.
He's a doctor.
Yes, he can still go and teach there.
And be a professor.
And professor, yeah.
A professor of law.
Yeah.
Maybe academia is where he needs to be. I don't know.
No, it's good where he is. I just don't want him in this case.
Not this case.
In fact, it's okay. He can be in this case. But I don't want him to talk. I like when he's doing research.
You don't want him to talk? Oh my God, Mr. Anonymous, now let's wrap it up.
Yeah, say goodbye, guys. Before I say something, next thing, you guys, you're not going to bail me. Bye-bye.
Bye, guys.